Okay. I want to thank everybody for joining Pennsylvanians for Modern Courts for this presentation on protection from abuse. I am Deborah Gross. I am the CEO of Pennsylvanians for Modern Courts. I apologize that I am sitting in a car at the moment because I have another presentation in 45 minutes. But we are joined today by, first I want to also thank the Montgomery County Library for collaborating with PMC to host this presentation. We are joined today by Noah Marlier, who is the prothonotary for Montgomery County, and Pam Gwaltney, who is an attorney as well as a member of Pennsylvanians for Modern Courts Board. And sorry for the noise that's happening. And Ann Cornell, who is at the prothonotary's office in Montgomery County. So Pennsylvanians for Modern, oh, actually, I guess we should start our PowerPoint. We're going to share a PowerPoint before this.
It's on, Debbie.
Oh, sorry. Okay, that's
okay. That's okay.
Working from the car. So, so I want to just tell you about Pennsylvanians for Modern Courts. We are a legal nonprofit which provides a number of these educational programs about the courts to support access to justice. There are a lot of individuals who go into the court system, don't have an understanding, and we want to give them a comfort level when they enter the courtroom. The courtroom is a place where you should be able to get, justice and be treated fairly. So I'm going to pass the program over to Pam and Noah and Michelle. Michelle, why don't you take the lead first?
Thank you everyone for joining us. And as Debbie said, I'd like to thank the library for hosting us. With this collaboration and with this presentation, I'd like to just let everybody know that we will be recording this program and you will be able to see this program on PMC's website at pmconline.org and the library's website after the program. So if you have any questions that are private, that are questions that are not legal advice, please go ahead and ask those questions at the end of the presentation. Now I'd like to turn it over to Pam.
Good evening. We are going to start by giving general information about what a PFA is. PFA stands for Protection from Abuse Order, and it is a civil court order to help protect victims of domestic violence. It provides them relief from abuse by an intimate partner, a family, or a household member. In 2020, the number of PFAs filed decreased by 11% from 2019. In 2019, there were 39,132 protection from abuse orders filed. And in 2020, that number dropped to 34,678. A bird's eye view of the counties in Pennsylvania and the top 10 counties with the highest number of new PFA cases in 2020. Philadelphia weighed in with the most at 19%, Allegheny County, 10%, and we have Montgomery County, Luzerne, York, Berks, and Lehigh coming in with 4%, and Dauphin and Lancaster and Northampton County with 3% of the PFA cases in 2020. The Administrative Office of PA Court Stats reported so far this year for PFA petitions filed each month in Montgomery County in 2022. January, there were 134, February, 112, March, 156, April, 145, May, 172, June, 169, and in July, 166. No numbers have been reported yet for August or September.
Pam, I just want to interrupt you for one moment and just say that a lot of this information we have gotten from the Pennsylvania Administrative Office of the Courts, and they're currently in the process of updating this information. But during COVID, some of the courts were closed, but for PFA hearings. And so they're busy in the process of updating this information. And I'm sure Noah can talk to how the court handled PFAs during COVID. So thank you.
So here are some answers to some frequently asked questions regarding PFAs. And so as Michelle mentioned earlier, much of the information comes from other sources. And at the end of the presentation, we will have information about those references and sources so that you can utilize and refer to them. So what is abuse? Abuse is causing, trying to cause, or threatening to cause physical harm. It can be rape or sexual. It can be putting someone in reasonable fear of immediate and serious harm, stalking or performing acts that would put someone in fear of harm, kidnapping, which means removing someone from one location to take them to another, or extreme control. Who may file for a PFA? Adult household members or an adult who is a guardian of a minor child, or individual that has a relationship with one of the following to the abuser, either related by marriage, and that can be spouse or in-laws, related by bloodline, meaning parents, children, or cousins, biological parents of a child, or current or past intimate partners, sexual and or dating. So I think it's important that this information is shared, because I think many times individuals think that it just is an intimate partner or a spouse, but it is broader. We're glad to present this information so that everyone understands who would qualify. What types of protection may I seek? Stop abuse of adults and children, exclusion of the alleged abuser from the residence, suitable housing, temporary custody or visitation rights, pay, spousal or child support or health insurance, obtaining a no contact order or harassment order of victims of abuse, and that would include extended family members, having the alleged abuser relinquish weapons, or being ordered to pay reasonable economic losses due to abuse. I'm going to turn it over to Noah, and Noah's going to talk specifically about the process in Montgomery County.
Thank you so much, Pam. And for those watching this evening and for those who are going to watch in the future, my name is Noah Marlier. I am your Montgomery County Prothonotary. It's an elected position. I run the Prothonotari's office, which is about 28 employees. And the main function of the office is to be the recipient of legal filings. So it's where you would file a legal paper, not criminal matters, but almost every civil legal filing is filed, docketed in my office. And then it's held in my office in digital form, typically. So again, this isn't criminal matters, but civil matters filed in my office. And some of those civil matters would be protection from abuse. So like Pam was stating, if you're seeking protection from someone who's abusing you, whether it's an intimate partner or a family member, you can do so by coming into the courthouse in Montgomery County, which is in the county seat, Norristown, and seeking that protection. And there's a few different steps to remember about this process. And I'm going to go through those steps, and it's important to remember that this is a very serious process. It's a legal process. You'll be seeing a judge at certain points throughout this process, and everybody wants to get it right. Everyone wants to make sure we're treating the petitioner with dignity and respect, and treating the process with dignity and respect. So you're going to hear a number of steps. It may seem daunting, but I think that's why. There's a number of steps to make sure that things are done correctly. First and foremost, the first step you would take is to come into the courthouse in Montgomery County in Norristown. It's on the Swede Street side. A lot of construction at the courthouse now, and there will be for a number of years, frankly, as they build the new Justice Center. The Swede Street entrance is the one to go to. And you can get the process going, your first step, by coming down to my office, which is the Prothonotary's office on the first floor of the annex. So you go in the Swede Street side, you follow Swede Street entrance, you follow the signs, go down to the Prothonotary's office, and we'll direct you to the Women's Center, which is an organization, a wonderful organization that has one of the rooms in my office we provide for them. And they have counselors on staff there to assist you to get you started with the process. So you'd fill out a PFA packet, and they could provide some counseling as well. And if you don't want to go to the Women's Center, you can go directly to court administration on the second floor to fill out the PFA packet. And that packet will take about 45 minutes to an hour to fill out. The second step, after either
No,
going to
I'm going to interrupt you for 1 second. That packet's available on the website, correct?
I believe it is, and we're actually working potentially, Debbie, on trying to create a digital packet. We're working with Laurel House and with the courts.
Okay.
We're trying to make that work. It could be challenging, but we're looking
Yeah,
at it.
it's on the pacourts.us website, not necessarily tailored to Montgomery County, but available for the Commonwealth.
Fantastic. And that could cut down on some of the time there. So thank you, Debbie. Appreciate that. The second step would be going to the second floor, taking that packet up to court administration. You may be there already, or you may be at the Women's Center. You go back up to court administration for them to review the packet, and they go over that packet. They make sure that everything's been filled out properly. And step 3 would be going back down to the first floor to my office, the Prothonotary's office, to have a PFA analyst, one of my staff, look over that packet and enter that packet, that information in the packet, into a statewide database. And from that, there will be a 3-page petition that is generated. I will tell you, and I want this to be the thing you remember, those who are watching, that the people that work in my office, I can speak to them. They're wonderful, and they're there to help you, and we're here for you as a resource. And they'll walk you through that process, review the packet with you, make sure that the questions that you've answered them in the way that you wanted to answer them. And that then generate that 3-page petition. And that petition is what's going to go to the judge. So we'll review that for accuracy with you, and make sure you've answered in the way you want to answer. And that will take about 30 minutes to 45 minutes. And then the fourth step would be actually going to the courtroom. In this case, because of the COVID world we're living in, you'd go to video room 1 in the courthouse. And that actually is over in 1 Montgomery Plaza right now, I do believe. Excuse me, no, video room 1 is in the courthouse. So you'd go back up to the first floor of the courthouse, the main courthouse building, and there you're going to have a conference with the judge. Some people will refer to it as a temporary hearing. Some refer to it as a conference. It's what's called ex parte, typically, where it's one-sided. The petitioner comes in and they're seeking a temporary PFA. And so there might not be the other side there to talk about their side of the case, the defendant. Typically, it's what's called ex parte, where the petitioner is talking directly to the judge via video. One thing to remember is that typically only the petitioner is allowed, and I'll talk about if you have children with you or not in just a moment. Step 5, if your temporary PFA is denied by the judge, you can still you have to come back to my office, to the Prothonotary's office, and you still have a right to a final hearing. Typically, most often people withdraw at that point because a judge has deemed that you can't get he or she is not going to grant the temporary protection from abuse. But you have the right for a final hearing. If it's granted the temporary protection from abuse, you still have to come back to my office, and you'll get 3 copies of some documents. The petition that was generated, the 3-page petition generated from the packet you filled out, the order from the judge granting the temporary protection from abuse, and the notice for your final hearing, most likely going to be within about 10 days. And you're going to get 3 copies, one for yourself, one that you need to deliver to your police department, and one that you need to right away deliver to the sheriff's department, which is right next door to the prothonotary's office. So that's step 6. You'd go to the sheriff and bring the copy so that the sheriff can serve it on the defendant, the person with whom you're seeking protection. And then step 7 would be the final hearing. Like I said, most likely within 10 days, you'll go directly to the courtroom that's on your notice. And that's where that has been, in courtroom 18, which is actually across the street from the courthouse in 1 Montgomery Plaza. It's the beautiful building across from the courthouse. And you'd go up to courtroom 18 for your final hearing. And there you will have a hearing in front of a judge, not virtual, not over video, but actually in a courtroom face-to-face with the judge. The defendant also is getting that notice from the sheriff, so the defendant most likely will be there as well. And that would be your final hearing. Some important things to remember, and I welcome Pam to jump in here if she has anything to add, but a couple things about the process to remember from our perspective. Across this is a long process, like I said, it's a number of hours long. You really ought to probably allocate 3 to 6 hours. Okay, that's number 1. Number 2, regarding timing, you really want to get to the courthouse before noon. Because the process can typically be a number of hours, you don't want to get there after noon because we may not accept it. Number 1, we may not accept your petition that day. We may ask you to come back the next day because it just takes a while, and we wouldn't want someone to walk in at 3 o'clock and it just can't get heard that day. Because it's such a long hearing or such a long process, I would point out that there's food trucks across the street. There's a restaurant or a little deli in 1 Montgomery Plaza. Children are allowed in court administration. Children are allowed in the prothonotary's office and in the women's center. But court care is available through the county. So you would want to go to the county website before you come to our office to petition if you have children and you want them to be looked after and cared for while you're going through this process. Translation services are available and will be provided for the hearing. Not necessarily though for when you're talking to court administration and talking to people in my office. I will say we do have Spanish speakers in my office, so I will say that. Off hours, and this is a question I get a lot. If you need protection off hours, not during the day that the courthouse is open, you should go to your police department. You can get a temporary protection from abuse from the local district judge or the district judge on call in the county. So if it's after hours, there's a DJ, district judge, which is the local judges, that's on call, and they can grant a temporary PFA that's only good until the following day that the courthouse is open. Get it on Tuesday after hours. It's most likely the Wednesday morning. You have to get into the courthouse to go through the process I've just described to make sure you get a true temporary PFA to allow you to get a final protection from abuse order. Most of the time, fees for protection from abuse are waived by the court. So we wouldn't want money or financial burden to be a hindrance for anyone. So I have a few other things we could probably talk about, but I'll turn it back over to Pam because I've been talking for a while.
Can we go back a slide? I'd like to talk a bit about what happens after the petition is filed. So after the petition's filed, Noah gave a very comprehensive look into the process and the procedure, the practical information that you need. But it's good to know that something happens after you file it. So if the individual is alleging an immediate and present danger of abuse to himself or minor children, as Noah mentioned, there's going to be that ex parte proceeding. And that means that the judge is going to speak with the individual to actually determine whether that immediate danger of abuse exists. And to determine whether an immediate and present danger of abuse exists, the court is going to look at the following factors. And I think it's important to know these factors. In my past experience working with individuals who were getting these, it's a very emotional time. and you don't understand why someone doesn't want to give you an order, right? And so it's good to understand, what a judge is going to be looking for. All right, so the judge is going to be considering the following factors: whether the temporary order of protection from abuse is likely to achieve the purpose in the absence of such a condition, whether the defendant has previously violated a PFA order. So in this instance, the plaintiff would be the person who is requesting the order. The defendant is the one that the plaintiff is requesting to be protected from. Another consideration: whether past or present abuse to the victim or the victim's minor children resulted in injury, whether the abuse occurred in public, and or whether the abuse includes threats of abuse or suicide, killing or threatening to kill pets, an escalation of violence, stalking or obsessive behavior, sexual violence, or drug or excessive alcohol use. And it's important to note that over the years, these factors have drastically increased, right? The court is looking at more than they used to maybe 10, 15, 20 years ago, taking into consideration the evolution of relationships and increased violence and heightened violence. So it's important to know that. Next slide. So what happens after the temporary order? The temporary order is only going to last until the date for the final hearing set by the PFA court, where both sides may present evidence to the judge. The final hearing is going to take place, or hopefully, ideally, within 10 business days of the issuance of the temporary order. I think Noah can give a good idea as to whether or not they've been able to maintain the 10 business days.
They have. That my understanding is that it's almost always within 10 days.
Good. That's important. Next slide. So this is a staggering number. In 2020, 34,678 new petitions requesting relief under the PFA Act were filed. 89% of temporary PFAs filed valid until a final hearing were granted. It's a little small for me. If you can see it, Noah, you can jump in.
Sure. Yeah, I think this is some good resources for people that are looking for help. And oftentimes with PFAs, due to the nature of what a PFA is, the petitioner might be under some financial constraints and can't afford an attorney to represent them at a temporary hearing and then a final hearing. That can get expensive. So some resources that may be available for petitioners. Legal Aid of Southeastern Pennsylvania is wonderful. And we've been working in my office with them on a number of projects and gotten to know them very well. Lawyer referral services. I think this is referring to the Bar Association, I believe, but the Bar Association of Montgomery County could be a resource to find some at least reduced cost legal assistance. And then on here as well as free legal representation. It looks like, yeah, the Legal Aid of South, that's what these resources are. Right. But again, you can get private legal representation yourself. And if you come into my office, for the temporary protection from abuse, we have literature that has a number of different resources on there for people that might want to try to find legal representation for the final hearing. Because again, the final hearing, it's not ex parte. You have the defendant on the other side, and it's a hearing, and there's testimony back and forth, and people might want to be represented. That's
right. It's important that both sides get to tell their version of what happened or what is going on. Next slide. So how is the abuser notified of the protection order? Noah alluded to it earlier, but both emergency and temporary orders are issued without the abuser actually being present. So a victim of abuse who files for a PFA, as I mentioned, is the plaintiff. So the plaintiff is responsible to serve the defendant with the temporary order. And so, as Noah mentioned, you would take that order to the sheriff for service. and the sheriff where the alleged abuse will find the alleged abuser where he or she or they live or work, and serve him, her, or them with a copy of the temporary order. And again, as I mentioned, the alleged abuser is known as the defendant for the purposes of this proceeding, even though it is not a criminal proceeding. The affidavit of service must be brought to the final hearing. Next. So what to expect at the final hearing? The final PFA hearing is scheduled date and time for the defendant to appear in PFA court to either contest or consent to the issuance of the final PFA. If the plaintiff does not appear at the final PFA hearing, the temporary PFA order may be dismissed. The plaintiff may withdraw the request for a PFA, and the temporary PFA order will then be terminated. Continuances. A temporary PFA order may be continued, and a new final PFA hearing date may be rescheduled for a number of reasons. First, continuances may be granted when the sheriff or law enforcement has been unable to find and serve the defendant. Second, the defendant requests more time to get legal representation. Or third, either party or their attorneys makes a reasonable request for a continuance and provides the court with the reasons for that continuance. Noah, you want to talk about what to expect at the final hearing?
Sure. So as you can see here, the final PFA order may be issued by default if the defendant does not appear at the final PFA hearing and there's sufficient proof. In your experience, Pam, I don't know how much experience you have in Montgomery County, but in your experience, will a judge oftentimes, even if the defendant doesn't show up, want to hear a little bit of testimony from the petitioner and then grant almost by default?
The judge is going to probably look at the reason why the PFA was issued. And if the defendant doesn't show up and the defendant was served, and based on the facts, if it seemed likely that the defendant wouldn't come anyway, and if the plaintiff was in grave danger, then it's in that situation, it would be quite possible that the judge would go ahead and issue it if they believe the defendant wasn't going to show up based on the circumstances alleged.
Right. And oftentimes the second possibility here for a final hearing of an order by consent, I think this happens quite often, that prior to a hearing, the parties will discuss kind of a negotiation and negotiated settlement by agreement. This is a way to not have a hearing. And of course, I believe it still needs to go in front of the judge, though. You negotiate and go before the judge, and the judge issues an order by consent.
That's correct. Next. So what to expect at the final hearing, the final PFA order after a hearing. If the parties cannot negotiate a settlement of the case, a final PFA hearing is going to be conducted by the judge. At that hearing, both parties may testify and present relevant witness testimony and evidence about the case to the judge. And then the judge is going to decide if the final PFA order is issued, and if so, how long of a time period it will be issued for. How long can a PFA order last? So emergency orders only last until the next business day, as Noah discussed. If one is granted overnight, it can last hours. So it'd be important for the individual, the plaintiff, to come back the next day to refile. Temporary orders are in place ahead of the final hearing and last up until the final hearing. And then final orders can last up to 3 years. There'll be instances where the judge may believe that it is reasonable to have a final order last for that period of time. A judge can extend any of the orders if they feel that the plaintiff is still at risk or if the defendant violates the order. So what can a PFA order do? Any number of things. The order can direct the defendant to refrain from abusing the plaintiff or minor children. The order can actually prohibit the defendant from having any contact with the plaintiff or minor children, including the place of residence for the plaintiff, where the plaintiff works or attends school. The judge can grant exclusive possession of a shared residence. The judge can award temporary custody or establish temporary visitation rights with regard to minor children. The judge can direct the defendant to pay the plaintiff financial support in the form of rent, in the form of health insurance, or other expenses deemed necessary. The judge can prohibit the defendant from harassing the plaintiff's relatives. The judge can also limit the defendant's ability to have a gun or a gun permit. And the judge can direct the defendant to pay the plaintiff for reasonable losses suffered as a result of the abuse, including medical, dental, relocation, and moving expenses. Also counseling, loss of earnings, attorney's fees, and or repair or replacement of any real or personal property damaged. Noah, you want to talk a little bit about the PFA case outcomes?
Sure. And what I would also, I forget, frankly, if there's a slide on this, but one of the things I am familiar with is as a former DA, is the handling of indirect criminal contempt matters. So if someone violates a protection from abuse. So as Pam pointed out earlier, protection from abuse, a PFA is a civil matter. Plaintiff, defendant, petitioner, defendant, rather than the Commonwealth versus a defendant. When someone violates a PFA, it's almost like a quasi-criminal matter where the district attorney will represent the Commonwealth in that hearing. So all the things Pam just talked about, it's very important once that is issued, that the petitioner be very cognizant about what is going on, the interaction, keeping the interactions with the defendant at a minimum, but the defendant, obviously, it's on them. This is an order binding them from having certain interactions with the petitioner. So it's important to remember. But regarding the case outcomes specifically, as you can see here, the statewide totals, I believe these are statewide, correct? The plaintiff does not appear in court. That's about 24.
Sorry, they are now. They're statewide totals. Sorry.
Thank you, Debbie. I'm sure these statewide trends tend to also trend in Montgomery County as well. I'm sure they're very similar. But as you can see, about a quarter of the petitioners do not appear in court. About a quarter of the petitions are withdrawn. Little less than that, about 18%, a final order will be granted. And about the same number, there's an agreement reached between the parties, which oftentimes can be the best result when both sides agree. Temporary order being dismissed or denied. So of course, again, just taking this a step back, a temporary PFA has been issued. We're now to the final hearing, and it's denied in about 12% of cases. Temporary order dismissed or denied. So that's the first step, about 12% of the cases. So not too many, but then in the final order, about 5% are denied. And of course, I jumped the gun a slide and started talking about indirect criminal contempt. I apologize, Pam.
That's okay. So let's talk about the two different types of provisions within PPFA orders. The PFA order is composed of many sentences and sections. It's a legal document. And some of these sections or provisions guarantee the safety of the plaintiff and any other abused person. And these provisions include no abuse, exclusion from property, custody, no contact, no harassment, stay away orders from work, from school, and giving up weapons. So these are safety provisions. A second type of provision does not involve any physical safety, and these are non-safety provisions. They discuss support, damage, attorney fee payments, and orders for the defendant to go to batterers counseling. What happens if defendant violates a safety provision? The plaintiff should immediately call 911 and request police support. Local law enforcement may be able to arrest the defendant for violating the PFA order, and then we go into the criminal territory, which is what Noah was referring to. A plaintiff may file an indirect criminal contempt complaint for violation of a PFA protection from abuse order, and arrest warrant may then be issued so that the defendant may be arrested. Noah, you want to take over this slide?
Sure, and this is what I was mentioning just a few minutes ago. I apologize, I was a little quick on that, but as Pam was saying, in an indirect criminal contempt hearing, if there's enough evidence that the defendant might have violated the PFA, they will notify the PFA court, and the contempt hearing will be scheduled, and it will again go before a judge. Like I said, a district attorney often will, in Montgomery County at least, be present at those indirect criminal contempt hearings. And the judge will have to determine if the PFA was violated and how the defendant will be punished. Sometimes PFA is violated in many, many different ways. It could be an actual criminal act. Someone could assault someone. It could be not a criminal act. It could be communication over the phone, communication driving by someone's house when that's part of the PFA. They can't do that. I've seen indirect criminal contempt matters when people interact with someone over social media if the PFA stated that they cannot do that. So depending upon what is the violation, the nature of the violation, there can be fines up to $1,000, but there could be jail time. And I, in my experience, I did see jail time in some circumstances of up to 6 months.
So what happens if a defendant violates a non-safety provision? The plaintiff has to file a motion for civil contempt with the PFA court to schedule a hearing. At the hearing, the plaintiff and defendant will appear before a judge who's going to determine whether or not the defendant has violated a non-safety provision of the PFA order. The defendant is not subject to being arrested, sentenced to jail, or to pay a fine for these type of non-safety provisions. The judge may modify or extend the PFA order as a result of the civil contempt hearing. So, for example, if a defendant is ordered to make a payment and they're not working at the time, the judge might hear evidence that the individual is not working, and it wouldn't be reasonable to try to force them to pay money that they don't have, and may instead extend the period of time for the defendant to pay those monies. So again, the judge is going to review on a case-by-case basis and make a decision that is best for the plaintiff. So, Noah, you want to talk about the domestic violence program resources that are available?
Sure. So some of the resources that we see on the screen right now: the Pennsylvania Coalition Against Domestic Violence, the National Coalition Against Domestic Violence. We have some amazing organizations here right here in Montgomery County. Laurel House is a resource, and we have Laurel House on all our literature. The Women's Center of Montgomery County, and as you can see here, they have a hotline as well, and Laurel House now has a hotline. The Victim Services Center of Montgomery County is also a resource. So I think those, and legal aid, as I discussed before, is just a wonderful group of attorneys who will represent petitioners in a PFA matter. I don't think they represent defendants.
So we've all probably heard about the lives of women who've been saved by using this hand signal. But this is the Violence at Home Signal for Help, which is basically the palm to the camera, tucking of the thumb, and then trapping the thumb within the hands. There have been at least 2 situations that I know of nationally where women and young girls have been saved because someone saw that signal, they knew what that signal meant, and they then attempted to got that person assistance.
And that's so important, Pam, in the COVID world that we're still living in. Frankly, this is over Zoom right now, and we've seen that happen. You know, especially when people are virtual like this. We saw during the pandemic, frankly, at the very beginning, a dip in PFAs, which was very scary because we knew that domestic violence was actually going up.
Right.
Absolutely. We try and share that information as often as possible. So I thank you both. Before we take any questions, I really would love for anybody that is participating or going to be listening to this recording in the future to please place your phone on this QR code and answer the survey. The questions are minor, they're simple, but it really helps with PMC's funding and our grants and all of the applications that we have to fill out. So now I'm going to stop the recording and I'm going to allow for any questions.